Hello, everyone. Fresh Talks once again. I'm Pedro Abreu, tax lawyer here at Fresh. I'm here today with a great lawyer, Daniel Russo, who runs our real estate department and also the part of the Fresh that take care of this important instrument that we have, which are the wills, which will be the topic today. And Daniel will help me on understanding a little bit more. I hope they can help you understand a little bit more of the importance of those wills in Portugal. So, getting straight to the point, Daniel, what would you say about this importance of a foreign having a will registered in Portugal? Why is it relevant, and how does it can help one that has assets in or out of Portugal?
So, Pedro, thanks for that question. Look, a will, it's very important. Worldwide, in Portugal, for an expat, it is especially important. Why? I don't know if you are aware of, but an expat can, if you want, do an opt-out solution from the Portuguese law and establish the law from his nationality to be the law applied to his inheritance. This is normal in the country where you are original from, but in Portugal, it's not normal to do it. And why is it important? It's important because you, I don't know, but I don't know if you are aware of, but in Portugal there are special laws, not special laws. The inheritance law is very strict. It's mandatory to follow the procedures described in law. For example, when an owner dies, it's mandatory to leave their assets to the spouse or the kids. Or if the spouse is already deceased, it's mandatory to leave everything for the kids. And there are, for example, parts of the inheritance that you cannot give to whoever you want. In Portugal, it's two-thirds that you can't give. Just one-third you can dispose whenever, how you decide. It's up to you. So creating a will that establishes an opt-out solution, it's very important. Another thing that I've been seeing, it's the importance of for someone who has kids. I don't know if you already have kids, Pedro.
I still don't.
You still don't. But if you were an expat living here in Portugal without more family, and you have kids, for you it was very important to create a will that establishes who will be the person that will take care of your kids in the event that you both parents die. This will help a lot. Why? Because if you that have a kid and your husband or your wife that have a kid die, who keeps your kids? The government. So in this, if there is a will who immediately says who is the person living here or not that should come to Portugal and take care of the kids will help a lot. And these children will not be in a governmental institution for a couple of months, let's say. And you know how is one life in the day of a child. It's very long and can bring them problems for whole their life. So these are two two kinds of situations. Now, there's a third one that I have a lot of clients that ask me. For example, in the event that my spouse dies, uh, the my assets or our assets will go to who? And in Portugal, it's mandatory that they, for example, if it is a wife and two kids, it's mandatory to divide between the three. If there is more than two kids, if there's four kids and a wife, it's mandatory to divide by all. But the wife cannot get less than one quarter. And there are a lot of nationalities who prefer, for example, if the husband dies, and sorry to all men, but normally the man dies first. If the man dies first, normally all the assets go first to the wife, and then after the in the event that the wife dies, then go to the kids. So these are the kinds of things that Portuguese law obliged to follow. Um, and it's very different from other nationalities.
That's very true, Daniel. As you all can see from the explanations, the thorough explanations that Daniel has given us, the estate planning is quite important when you are an expat in Portugal, making sure that your will confirm all of your willings and choices for the future. It's quite important, and making sure that if you have this option of applying the rules of your citizenship country, especially when you have assets on it and all a set of structures that were prepared in the past for it. Make sure that your interest is aligned with all those options by making sure that you have this will registered in Portugal. Daniel will be the right person to get this done for you. But Daniel, in terms of the procedures, what is needed for one to have their will recognized in Portugal and all the choices and willings that they have for the inheritance to be registered.
Okay. So in terms of procedure, we have to separate two different steps. First, I'll speak about what it needs to be done in Portugal. What needs to be done is we need to do a deed where the heirs are established. Normally it's the holder here that creates that deed and and that communicates who the heirs are, and with that deed then you then divide the assets and you go to tax authorities to register it. But there are a lot of situations where the heirs are outside, so you have to do this part, and you have to bring documents from the countries or where the heirs are certified, normally with apostille, to grant that those heirs are the legitimate ones. In the procedure, we will also have to speak about tax, which is normal. And in Portugal, look, there is inheritance tax. The inheritance tax is 10%, but direct heirs in a straight line are exempt from paying taxes. Wife, kids, parents, they are completely exempt. The tax exists, but they will not need to pay it. Other heirs besides that, like siblings, cousins, things like that, like this situation, they are obliged to pay a 10% tax. So this is more or less how it works. It takes some time, but yeah, well, it's how it's done in Portugal.
Great, Daniel. Thank you very much for these explanations. Let's say that someone has real estate in Portugal, and let's say that this person wants to make sure that this is also included accordingly to whatever a choice they make for the whole heritage. Can this property be included in the will? How does it work? What are the consequences after that?
Look, you can include in the will all assets that you have, real estate or not. I personally don't like to include because what we have today, it's not what we'll have tomorrow. So what we normally do in freshing, look, it depends on the situation of the client in what it's needed. But what we normally do, it's generally apply that will to all the assets that exist in Portugal. Um, Whether it is a real estate or a bank account. And then those assets will be divided according to the will and according to the inheritance law. That's what we normally do. Not specifying, it's always better. Unless you want to divide this home to one of my kids, this other home to another. In those situations, yeah, you can do it. Otherwise, it will be divided under Portuguese law, or if you do an opt-out solution, it will be divided according to the law of your nationality.
Amazing, Daniel. Thank you very much. I do believe we have spent some time talking about this estate planning. We have spent some time talking about the wills, but I'm pretty sure that Daniel has questions of his own to be asked here.
I have, because I spoke about wills, but I know you know a lot about trust. So I want to know, and I don't know a lot about trust. So I want to know what you know about trusts.
So, Daniel, exactly. I do believe it's a good topic to be discussed because it's kind of connected with the idea of state planning trusts, or use it especially in the United States and a little bit on the United Kingdom to drive this estate planning in the country of origin. And a question that normally surfaces here at Fresh, especially because normally our focus is on taxes, is what is the treatment of these trusts that are set, especially in the US or in the UK, when compared to the Portuguese tax law, and what are the consequences related to it? So we can divide the consequences of holding a trust like that into major stages. One would be while the trust is still active. So you are basically a tax resident of Portugal. You are a beneficiary of a trust, and this trust produces income to you through distributions. In this case, what we have is a taxable event according to the Portuguese tax law, although trusts don't quite exist in the civil law of Portugal, so the contract is quite hot, but the tax law has this disposition related to the distributions coming from a foreign trust. And this foreign trust, when distributed to a Portuguese tax resident, those distributions will be exposed individually in the name of the tax resident at a flat rate of 28%. Credits from taxation that occurs in the country where the trust is set. It could be the US, for example. If the trust is taxed in the US for the portion of those distributions, you can use those taxes to offset your tax liability here generated by those 28% that I have previously mentioned. So this would be kind of the first stage of what a trust can be. In between, we have a discussion about all trusts will be treated the same. So all distributions taken from a trust will always be treated the same under this 28% flat rate in terms of taxes. Is there any other factor that we should take into consideration here? And there is. Not all trusts are set the same, as most of our clients and US expats know. A trust can be set in different manners. They can be revocable or irrevocable. They can be discretionary, non-discretionary, and not necessarily the structures of who is the settler of the trust, who is the trustee, and what the beneficiaries follow the same rationale. Sometimes the settler is the same figure of the trustee, that is the same figure of the beneficiary. Sometimes you have a familiar trust where the settler or ascendants and the trustees are the ones who are managing those assets, or a third party, and the beneficiaries would be the equivalent to the heirs of those ascendants that have set the trust and whose the assets that are inside the trust belonging to. In this two different manners of structuring a trust, we can say that CFC rules, which are rules designed to establish connections between foreign structures and the country where the beneficiaries live and are tax residents, they can be applied in the case of a trust that is being managed from Portugal, let's say. And this presence here could be established through a set of rules in the Portuguese legislation. And normally, the bottom line is if the trust is in a blacklisted jurisdiction, or if you hold major participation, or if the trust is not taxed in the source country, CFC rules might be applied. And what are the consequences of that? The consequence of that is instead of the taxation on 28% on distributions that we have told, this trust will be seen as transparent. which means that all income produced in the trust will be taxed in the personal level of the beneficiary, because in this case of revocable trust, where the beneficiary is the same figure of the trustee, that is the same figure of the settler, could be exposed to that. A way of plan around it is to establish clearly that this trust either is managed or it is effectively taxed in more than 50% of the corporate tax rate of Portugal. Again, there is some planning that needs to be done in this sense. So I recommend that if you have a structure like that, you're more interested on understanding the consequences, that would be a good time to talk. And our firm deals with this kind of matter on a daily basis. So it's if you feel that you should have some planning around your trust, especially if it is a revocable trust where you are the beneficiary in Portugal, but you're also the settler and you're also the trustee. Let's talk about it. It's not the CFC rules are not automatically applied, and we can think a little bit about it. And if you need an analysis, you can come to us. A second stage where we can talk about trust connects a little bit more on what Daniel was discussing about in terms of state planning. Why so? Because this second stage of the trust would be in the moment of extinction or termination, or once someone revokes the trust. And what happens once this event takes place whilst a beneficiary is a tax resident of Portugal? Well, in this case, we need to analyze exactly what assets are being distributed or are being given to the beneficiary in Portugal in the event of termination of the trust. If the assets belonged to the beneficiary before the termination of the trust, which means if the beneficiary was also the settler of the trust, here what we have is a simple event of capital gains, which means that we need to establish what was the value of the trust when it was set, what is the value of the trust once terminated, and the assets distributed to this taxpayer in Portugal, to this tax resident of Portugal, will be taxed accordingly to the difference between those amounts as capital gains. If we're talking about a trust that is more designed and known as a familiar trust on the US perspective, that it's normally done for estate planning, then we need to treat the assets received by this beneficiary from a previous settler, normally an ascendant or a spouse, as basically inheritance. Okay, that's the treatment under the Portuguese law. You can have capital gains if the assets were yours, or it will be treated as inheritance, exactly as Daniel has mentioned before, which triggers on my mind that if we have an inheritance event, in the case of an extinction of a trust, it's quite important that maybe this trust should be in the will that you will register as a date on the notary for our clients who choose to opt out of the Portuguese law. And it's quite relevant to align what was the state planning that you have done in the country where you used to live and where probably most of your assets are, considering also the rules that Daniel just explained.
Yeah, it's true, Pedro. And we normally do in our wills, we normally always put the reference that all distributions, when we do the opt-out solution, all distributions go under a trust or a will or a state plan that exists in the original country of the nationality of that expert. Just one more question. I have clients that ask me also, um, why can't I incorporate my trust in Portugal? Is this possible?
So the idea of a trust in Portugal, normally as a standard, it's not possible because Portugal hasn't signed up to the convention that aligns the treatment of trust around the world. There is a treaty that governs that, and most European countries actually didn't sign it. So normally it's quite uncommon for someone to make this will of setting up a trust in Portugal real, because due to the restrictions of the Portuguese law around it and under contract law. What is possible is that under the Madeira Ilha de Madeira in Portugal law, there is a provision for establishing the representation of a foreign trust in Portugal to make sure that it is duly registered here. As I just explained, there is no way of setting up the trust from the Portuguese perspective. What you have is a way of making sure that your foreign trust it is recognized for legal purpose through this entity solely in Madeira. It's quite peculiar, but it could be relevant to some of our clients.
Yeah, but since we don't have the conception of a trust in Portugal, for sure it brings a lot of problems.
A lot.
Okay, thanks for everything, and we are here fresh for you.
Yeah, thank you very much, you all, for watching it. If you need services related to anything that concerns legal services in Portugal, if those are taxes, if those are wills, if those are immigration or real estate, we're here and we are prepared to deal with these specificities of the law that we have discussed today. Thank you very much for your time.